Hello, everyone. My name is Sushila Chanana, and I am a privacy and IP litigation attorney at Farella, Braun and Martell. I had a prior career in cybersecurity consulting. Prior to becoming a lawyer, I was a cybersecurity consultant at Pricewaterhouse, where what we did was we pretend hacked into systems to expose vulnerabilities and wrote up incident reports, etc. So to be now on the legal side of things is a full circle moment for me. And I really geek out on this stuff. I'm very excited about this. I read about this stuff in my free time, which I know is odd, but I really enjoy it. And I'm really looking forward to talking about some of the privacy litigation landscape and the CCPA litigation in particular. So I guess with that, let's get started. Margaret, do you mind going to the next slide? Great. All right, so folks, I'm sure you're joining this call. You already know that the CCPA came into effect earlier this year on January 1st. And before I get into the rights under the CCPA, of which there are many, I'd like to briefly take a moment to just point out that, at least in my opinion, the CCPA represents a cultural shift in our society globally. You know, AI is way more prevalent today than it was 10 years ago. We share a lot of our information online, electronically, in various capacities. And, you know, it's not just your name and your social, but it's the geolocation of your devices, information about your children. You know, if you've ever Googled yourself, and if you haven't, I suggest you try that. You will be amazed at what you can find out there publicly. And as a society, we expect companies that have our information to safeguard it and protect it. And of course, in the news, you often hear, and it's been more prevalent in the last few, I would say, 10 years, data breaches. And when you hear that, you worry about your data. You know, I'm sure folks on this call may have even heard of incidents where children grow up and realize, oh, my social has been used, you know, since I was 5 for various things, and now I need to deal with the hassle surrounding that to undo that. So the CCPA is a cultural shift in society, and then on the legislative side to protect our data, which I think is fantastic. So let's jump into some of the rights under the CCPA. Consumers have a right to know what data is collected about them and the purpose for that collection. They have a right to access their data. They have a right to have that data deleted, which is really, really important. And they have a right to know which third parties are accessing their data. You know, it's not clear yet to what degree, like, do you need to share every single company, or do you need to share, you know, the type of third parties that will see that. What I've seen with respect to privacy policies is primarily like a description of the types of third parties that would get access to your data. You also have a right to opt out of the sale of your data, and you have a right to equal treatment. And what equal treatment means is that you will be treated the same by the company, whether it comes to promotions or sales, regardless of whether you chose to opt out. Or if you chose to have your data deleted, etc. So let's move on to the next slide. All right, so in terms of the threshold requirements for a company to determine whether the CCPA applies to them, you want to look and be aware of 3 threshold requirements. And the CCPA applies to for-profit companies collecting information about California residents if the company, 1, has annual gross revenues of 25 million or more, or obtains personal information of at least 50,000 California residents, households, or devices annually. And I want folks to pay particular, you know, attention to that. Not just people or individuals, households and devices. And then third, gets at least 50% of its annual revenue from selling the personal information of California residents. So one big takeaway from that is companies do not have to be based in California or have a physical presence here to fall under this law. So, you know, companies outside of California are following the CCPA closely as well. Okay, next slide. Not surprisingly, just like many other laws, California is leading the way here. As you can tell, California and Nevada, I believe that's small on my screen, but Maine has laws that have been signed, privacy laws that have been signed. Some other states, things are in committee or they've been introduced. And I think this graph is going to start changing where you're going to see more red. You've got these gray states where they're doing nothing. But I think over time, over the next 5 to 6 years, we're going to see some changes here. And those states are going to look at not only the enforcement side of CCPA, but also the litigation side, the private right of action side. Next slide. All right, so speaking of enforcement and litigation, folks may already know that the CCPA allows the AG to pursue damages per violation anywhere from $2,500 to $7,500, and $7,500 applies if the violation is intentional. Separately, the CCPA provides for a private right of action where an individual can get statutory damages of anywhere up to $100 to $750 per data subject. Not surprisingly, you're not going to find individuals running to court for $100 to $750. What you're going to find is our class actions, and that's exactly what we've seen, just as folks have been predicting before the CCPA went into effect in the last 3-4 months. And we'll get into this later. The litigation that has come out, the private right of action litigation under the CCPA that has come out, they've all been class action lawsuits because the damages numbers are big, right? Because it's, again, per incident, per data subject. So everything's in the millions. All right, next slide. Okay, so back to the private right of action. Under the CCPA, an individual consumer may recover, like I said, anywhere from $100 to $750 in statutory penalties per incident if the unauthorized access was 1, due to unreasonable security procedures and practices, and 2, the compromised data was non-encrypted and non-redacted personal information. So I guess, what must scream out to you here is, okay, I gotta make sure my data is encrypted. So, that should be a baseline for everyone. And I will take a brief moment to expand here that there are many companies who don't consider themselves data companies, but my perspective is pretty much every company is a data company. You're housing data, you're housing customer data, and that mindset is really important culturally across the company, so that there's a baseline understanding that, okay, we need to protect this data as well. All right, next slide. Okay, so there has been enormous discussion around what is considered reasonable. Specifically, what are reasonable security procedures and practices? Now, the CCPA is not clear on that. And frankly, this is yet to be determined by the court. But the best guidance that I give to clients, and I pretty much has been universally accepted at this point, is companies should 2016 California data breach report that was issued by then Attorney General Kamala Harris, and it laid out 20 data security controls that were published by the Center for Internet Security. And some of those include, taking an inventory of your hardware assets, continuously doing vulnerability management. And what that means is, pretend hacking, trying to get in, finding out where your vulnerabilities are, and taking measures to address and fix those issues. And then having a plan with respect to data recovery. What happens if data is lost, if data is compromised? Who are you going to go to? What forensics team are you going to use? Who's going to be involved from IT, from HR, from legal? And if you're a smaller company, just maybe knowing who the 1 to 2 people are, but key stakeholders need to be involved in that process. And I highly recommend folks take a look at and, search for these 20 data security controls, because I would not be surprised if the case law develops in such a way that that becomes the baseline. At a very minimum, I expect defendants in these lawsuits over the next, whatever years, as they're defending themselves in litigation, to cite to these data security controls and say, look, we did everything we were supposed to do, that we knew to do, and so we acted reasonably. So the last thing I'll point out is that the current AG has not indicated whether or not he would follow these guidelines, but these are a good starting point. Next slide. All right, so let's briefly talk about the current litigation landscape with respect to CCPA. As I mentioned before, all of them are class action lawsuits. There are about 22, maybe 23. I saw a new lawsuit come in a couple days ago. And what's noteworthy is that 90% of them claim negligence or non-data breach claims as the primary theory for bringing these lawsuits. So, and I'll briefly, just an aside here, mention that there was a lot of talk initially about how the CCPA's private right of action was going to be limited to data breaches, but that's not the case, and that's not surprising, right? The plaintiff's bar is aggressive and creative, and rightfully so, is going to find opportunities in which you don't need a data breach to argue that a company allegedly acted unreasonably with respect to securing data and having appropriate policies in place. So at this moment, I'd like to share a little bit about what these lawsuits look like. Not surprisingly, there's some big names, right? Google, Facebook, TikTok, Salesforce, Zoom, etc. There's some smaller companies that have been hit with CCPA litigation. I've looked at the complaints, and I would put them in three different categories, the three different types of CCPA complaints. One, of course, relates to data breaches. Again, not many, but that's a category. Another category is just data privacy in general, where plaintiffs allege that defendants fail to meet the requirements under the CCPA. For example, maybe the defendant failed to properly disclose what information they had, what information they were sharing with third parties, and consequently, the plaintiff is seeking, for example, injunctive relief under the CCPA. For example, saying, update your privacy policies, put in more robust security practices. And then an interesting turn has been this third category, which is related to, I call them miscellaneous references. And these are just kind of throw-ins of the CCPA, where plaintiffs allege in the complaint that, because defendant acted unreasonably, they may have violated the CCPA. And I saw a recent complaint that actually said, we reserve our right to amend the complaint to seek damages under the CCPA. So it's definitely percolating there, which is interesting. And it's not surprising that there are complaints out there in which attorneys and plaintiffs are reserving their right under the CCPA, because the CCPA actually has a 30-day cure notice period. It provides that prior to initiating a lawsuit, a potential plaintiff must give the defendant 30 days written notice, identifying the precise CCPA provisions allegedly violated, and give the company 30 days to cure the violation, assuming it's possible to be cured, and provide the consumer with a written statement that says, 1, the violation has been cured, and 2, no further violations shall occur. If the consumer gets this written notification, this express written agreement, the consumer is barred under the CCPA from filing a lawsuit with respect to the private right of action, CCPA. However, not surprisingly, just like so many other provisions of the CCPA, cure is not defined. What's a reasonable cure is not defined. So it's not surprising that we would see complainants down the line saying, yeah, fine, you gave me this express written agreement saying the cure was done or taken care of and it's not going to happen again, but I don't think that's sufficient. So I'm still going to file this lawsuit. So those kinds of lawsuits have yet to be seen. I haven't seen that yet, but expect some case law to develop around that too. You know, whether what was said in the written agreement saying that it had been cured, whether that was sufficient, whether the plaintiff was still within its right to continue pursuing this. And then another word of caution I would give here is to be careful what you say in your written statement. Because if, for example, you say in your written statement, yep, we've cured this, we've taken care of it, it's not going to happen again, well, what if there's a breach later? Now, under the CCPA, that same plaintiff or intended plaintiff can now seek an action to enforce the written statement and pursue statutory damages for each breach of that express written statement, as well as any other violations of what was provided in the written statement. So another thing that we're doing is counseling companies on what does your express written statement look like? And to those folks who are in-house and even, on the executive side of things, make sure there are people looking at what kinds of promises that are being made in these express written statements if, you find yourself having to write one. I just briefly, with respect to some of the CCPA litigation against Zoom, what we've seen is plaintiffs saying in their complaint, oh, we sent the notice, the 30-day cure notice, we're waiting to hear back. If the response is, not sufficient, we're going to pursue, we're going to continue with our CCPA claim. So that's how plaintiffs right now have reserved the right. They're not even waiting for a response for companies. So it's more preemptive. And I wouldn't be surprised if those plaintiffs come back and say, oh yeah, that express written statement wasn't good enough. Let's charge forward. Okay, so let me also share with you guys the fact that CCPA claims, these lawsuits, the complaints don't just have CCPA claims. They've got other causes of action as well. And some of the more prominent ones include violation of California's unfair competition law, invasion of privacy under the California Constitution, negligence, and breach of an implied contract. So they're really coming at defendants with, through various angles. Briefly, the types of relief sought in some of these complaints includes anywhere from asking the court to enjoin the defendants from engaging in the wrong conduct, compelling, defendants to implement certain security policies and procedures, restitution, disgorgement of the revenues wrongfully retained. Some include relief such as asking defendants to pay for 3 years credit monitoring services, and then of course punitive damages and attorney's fees. So there's a lot, there's a lot to digest, and there's a lot at stake. So I'd also like to use this opportunity to share with you a cautionary tale out of the Eastern District of Virginia. So this is not a CCPA lawsuit, but it could very easily find itself, this reasoning from the judge could very easily find itself in a CCPA lawsuit. So in this Capital One consumer data breach case out in Virginia, the judge recently issued an order that said the instant response report that a forensic company put out after a data breach was not privileged, and it had to be disclosed to the other side. And some interesting facts there is that basically Capital One back in 2015, engaged a forensic firm to routinely, check, do updates, make sure proper security protocols were in place with respect to data, and prepare incident response for reports should a data breach occur. So in 2019, 4 years later, a data breach does occur. And now, prior to litigation, the Capital One's law firm reaches out to the same forensic firm and says, give us a report, an incident report on what happened and how we can make improvements based on this data breach. And plaintiffs obviously get wind of this, and they ask to see a copy of that report. And Capital One says, no, this is privileged, this went to our lawyers. But the judge rejected that argument and said, hang on, you engaged this forensic firm 4 years ago. It was a business expense, not a legal expense. The fact that later your law firm came in and signed an identical engagement letter and said, send the report to us first, doesn't matter. It's a business expense, it's routine business, this is not privileged. So, one of the big takeaways there is, this company is being prudent and he's engaged this forensic firm, as many companies do, right? To routinely check in, make sure everything's okay. And then when a breach happens, now the other side gets to see exactly what you did wrong and how to fix it. And this would give plaintiffs significant ammunition to use against you. I highly recommend that if companies go down this path, you've got your forensic firm who's routinely doing check-ins. Well, if a data breach occurs, hire a separate forensic firm through your law firm. Make sure the expense is a legal expense, because the judge in the Capital One case also pointed out, well, see, if you look at the books, this was identified as a business expense. It did not come out of the legal department. So that's another reason that this was not in anticipation of litigation. It's not privileged. That's just an interesting order, and I wouldn't be surprised if something like that starts to happen with respect to CCPA litigation. All right, let's go on to the next slide. Okay, so we're now briefly going to jump into what have you done to prepare, and are you ready? Next slide. All right, so litigation is scary, and when you think about what's at stake, it can really be troubling. So at this point, what I'd like to talk about is what can you do today so that in the event you're faced with a CCPA lawsuit, you can raise your hand and say, I acted reasonably, Your Honor. Even though this happened, even though data was compromised, I acted reasonably, I encrypted the data, and so I should not be held liable. And so the first step is knowing your data. Do data mapping with your IT and HR folks and know what you're collecting. The second one is, making sure your policies and procedures with respect to data and privacy are reviewed and updated, and that there's a procedure in place where, after 3 months or 6 months or whatever, someone is looking at these policies and doing a substantive review. 4, bolster your security. And, it's not just encryption, it's not just the technical side of things, but even how you secure the server rooms, who has access to those rooms, who has access to sensitive information online. That should all be looked at. 5, check in with your vendors. When you're entering into agreements with vendors, know how they treat data and what they do to keep it secure. And 6 is not a shameless plug, but I will add, check in with litigation counsel before you make any promises regarding the treatment of data. Because I can tell you, you say something and you don't follow through, I'll be Exhibit A, out there, whether it's in a deposition or a filing, etc. So please keep that in mind. And, you know, I briefly wanted to talk about this graphic here. As you think about what data you're holding on to, looks like I skipped number 3, which was record retention and deletion requirements. One thing that we've noticed across the industry is that many companies are over retaining records and information. And 75% of that information contains some form of personally identifiable information. So take a moment, take some time to think about, do I really need this data from 2002, 2005? And I understand that might not apply to some of the folks on the call, but you know, maybe in 5 years, maybe in 8 years, check in and make sure you're not over retaining records and data and information, excuse me. All right, next slide. That's it for me. I guess we're right upon almost 10:30, so I think we're on schedule to now open things up. Happy to chat with the group and see what folks would like to discuss.